Hi, I'm Martin Pritikin, the Dean of Purdue Global Law School, the nation's first fully online law school. Welcome to this latest installment in our Distinguished Speaker webinar series titled The Department of Education, An Uncertain Future. This is an incredibly timely topic that's been in the news a lot very recently, and today we have not just one, but two distinguished speakers to discuss the topic. First, Derek Black is a professor at the University of South Carolina Joseph F. Rice School of Law, where he holds the Ernest F. Hollings Chair in Constitutional Law and directs their Constitutional Law Center. He is one of the nation's foremost experts in education law and policy. His research has appeared in the nation's top legal journals, including the Yale Law Journal, Stanford Law Review, NYU Law Review, Cornell Law Review, and dozens others. That work has been cited a number of times in federal court, including the Supreme Court of the United States, and has led to expert testimony regarding school funding, voucher, and federal policy litigation. His books include Schoolhouse Burning, Public Education, and the Assault on American Democracy, and most recently, Dangerous Learning, The South's Long War on Black Literacy. Derek, thank you for being here.
Thanks for having me.
Next, Scott Johnson has been a professor at Purdue Global Law School for the last quarter century. He has focused his teaching on and scholarship on both educational law and constitutional law, with an emphasis on integrating theory and practice. His advocacy work has resulted in a number of precedent-setting opinions, including Claremont versus Governor, which established education as a fundamental right under the New Hampshire Constitution. He serves as a hearing officer for the New Hampshire Department of Education and has participated in the administrative, legislative, and political processes by helping draft laws, testifying before legislative committees, and developing administrative agency rules and guidance. Johnson has authored a number of books and articles, including several textbooks on education law and special education law. Scott, thank you for being here as well.
Thank you. Thanks for having me.
Before we get started, just a reminder to those of you who are watching the audience, please feel free to post questions in the chat box. And as we go, we will do our best to try and weave some of them into the discussion or hopefully save a little time at the end as well. Okay, so let's kick this off. Instead of starting with the background, I kind of want to back into the background. Let's dive into the main event. This is in the news because something's happened with the Trump administration. What has the president proposed to do regarding the Department of Education, and why? Scott, do you want to kick that off?
Sure, glad to. The president has been clear that he is intended to close down the Department of Education, has issued an executive order directing the Secretary of the Education to do whatever they can to do that, as the law permits, is how it was worded, and then to work with Congress to, effectuate that. Some of the ongoing issues are how much they're going to work with Congress to effectuate it versus trying to do it without Congress. And that's part of the disputes that we're seeing now in the courts. And then they have also issued a RIF, reduction in force, to reduce the number of employees. And the president has stated, and it was just statement, but has stated that certain functions will be transferred to other agencies, specifically student loans and special education.
So let's back up a sec. So when was the Department of Education created, and why? Derek, I don't know if you want to take that.
Sure. Well, most people look at 1979, and that's true as the current iteration. But as I've tried to emphasize to folks, the Department of Education was first created in 1867 or 68, in the aftermath of the Civil War. And so, that's sort of important, I think, when we think about our larger democracy, when what we were trying to do was rebuild democracy at that time, trying to make sure that African Americans, formerly enslaved people, literally just months earlier, had access to public education. And so the department was first created during that period, but of course we know that Reconstruction doesn't end well, and so the department ends up getting relegated to sub-department status and living on in a smaller form until it's revived as full department status in 1979.
And so, in the decades leading up to 1979, when the modern iteration of the Department of Education was created, where were the various functions that the DOE does? Where were they living then?
Yeah, I mean, they were sort of scattered across numerous agencies. I mean, in my mind, the most important was Health and Human Services, which was doing all the DSEG work. The Office for Civil Rights was there. And so when we were desegregating schools in the aftermath of Brown versus Board of Education, it was Office of Civil Rights had HEW, Health, Education, and Welfare at the time. It's HHS now, but Health, Education, and Welfare, those folks were instrumental in holding out the carrot and the stick to try to ensure that Southern school districts desegregated. And so that was a big one to bring under the umbrella, but we also had, Department of Agriculture, sending out money for school lunches and things of that sort. I think Department of Defense had some money. I mean, it was just spread in a number of different locations across the federal administration.
And so it seems like efficiency and coordination was one of the motivations to having all those various functions under one umbrella organization. Is that fair?
Yeah, I mean, in fact, that was the one piece that I'll confess having been ignorant of prior to 79, because, most folks talk about, somehow or other this department was just created out of full cloth to serve the needs of, teachers unions and things of that sort. And I always jump to well, wait a minute, there's this democracy part that, I spoke about earlier. But if you look at the legislation, Congress is saying this is just a mess, right? It's all over the place. It's inefficient. We need to bring it together in one place. And so, surely the department has expanded over time with legislation like No Child Left Behind, et cetera. But part of what we're doing is just bringing it together in one location. I haven't looked at the stats, but I would venture to guess that there were probably more attorneys at the Office for Civil Rights, maybe in the 60s and 70s than there are now. I could be wrong about that, but it's not somehow that we've had this exponential growth at the department. If, in fact, on the civil rights side, it's been flat for some time and begging for more resources, to be quite honest.
And sorry, Scott, go ahead.
I was just going to say, just to add to that, part of the reason to put it in one place was so that the president could have more control over it. That's one of the interesting kind of dynamics or ironies of what's going on now. Is the idea was we'll put everything in one department, and that way there'll be more executive control over how the department and all the educational programs are run. Now the president's trying to do, disaggregate that and split it back out into various different departments.
And so is this the first time that anyone's tried to dismantle the Department of Education or talked about doing so since 1979?
It's not really. 79 was Carter and 80 was Reagan. And Reagan, part of their platform was to try to undo the Department of Education. Interestingly, Reagan's slogan back then was "Let's make America great again," very similar to Trump's "Make America Great Again." So there's a lot of parallels between Reagan and what the current administration is trying to do with the department. And that was not successful, in part because the legislature was all Democratic at that point, or Democratic majority, I should say. And we'll see if it's successful now. They get Congress support. It does require a supermajority vote, I think, to the Senate in order to actually undo or close the agency. And I think that's the sticking point at the legislative level. But there have been efforts almost consistently through that time period at some level. It tends to gain steam more or less in different time frames.
Now, one of the things I've heard without, getting into the politics of it, right? But, people say, well, education is typically something that's handled at the state level. Why is there a federal Department of Education? What are some of the key functions that the Department of Education currently does? Derek, I don't know if you want to take that one.
Yeah, I mean, before we even get into the specifics, I mean, that question, I've sort of tried to make a mockery of it, or not your question, but sort of the claim of returning it to the states, because, when you think about all the things that schools do, all the things that matter to families, right? Class size, teacher credentials, number of mental health counselors, number of books, spending per pupil, what time the bus picks up, how many times you can go to the nurse, how many times you can do XYZ before you're suspended. All of those things are decided in either the local school board or your state capital, right? The sort of idea that somehow the federal government is running our schools is just incorrect. There is this sliver of our education existence that the U.S. Department of Education has a huge footprint in, and that is civil rights, which is they say, look, we don't know what books you're going to read or not read. What we can tell you is you cannot discriminate against children based upon race, sex, disability, language status. We could go on, right? And so that has been the major footprint. Now we certainly have a testing regime, but even on that, the states get to pick their own tests, they get to pick their own curriculum, they get to pick their own pass rates on those tests, right? And so there is this I think sort of rhetoric that the administration has sort of put out there that somehow the federal government is running our schools. That's not true. And I think that's the notion that is the case is problematic, regardless of this conversation about Department of Education. I mean, people have a lot of legitimate concerns and complaints about their public schools. And as I was telling folks, well before the current administration, I would say this, and they didn't like to hear it. The federal government is not coming to save you, right? Because everyone walks around, oh, can the federal government fix this? No, that's not what they do. Like, if you have a problem, you need to take it up with your state legislature. I just think these guys have gotten a pass, and great work, Scott's done. He talked about his work in New Hampshire and Claremont. These state legislatures have been getting a pass because we direct all of this energy and attention at the federal government. A long way of saying, what do they actually do? Back to your original question, right? They enforce our civil rights statutes. They send out money for special needs students. So we put, English language learners, students with disabilities, low-income students. They also, have some other sort of more nuanced programs. And basically, they spend money on students that we think may not have enough, right? Or that may need a little bit extra, and they make sure their students aren't discriminated against. And then, over the last 20 or 30 years, we thought, well, a good way of making sure that money is spent effectively is to make them test students, annually in grades 3 through 8 and math and English, and then once every so many years in science. But again, it's still up to the states as to what tests they administer, what the pass scores are, and all that. So it's really a civil rights institution at the end of the day, if you ask me.
Well, and besides the civil rights aspect of it, I think one of the big pieces that most people are probably familiar with is federal financial aid, right? I mean, that affects millions of people. Scott, you want to talk a little bit about that piece of it?
Yeah, that's what I was going to say. I agree with Derek. And then there's some additional parts to that. Financial aid, student loans is probably one of the bigger ones. It's an extremely important part for post-secondary education. There's also a variety of funding programs for students who are in poverty at the elementary and secondary level. Title I is that program to help them with certain educational services, and then special ed. FERPA, student privacy, is another huge aspect of what the United States Department of Education does. And a lot of those are funding statutes. And then there's some that Derek mentioned that are not, like Section 504, discrimination against disabilities doesn't provide funding itself, but if you receive federal funding, they enforce it. So it's kind of a combination of funds to make sure certain services are provided, and then enforcement of various rights, including privacy, disability, gender, and race.
So pretty big things that affect, a lot of people at all levels of education, right? K through 12 up through, as you said, post, secondary and postgraduate. So let's talk about the Trump administration's current efforts. There's been a lot of court activity in the last few weeks, both at the district court level, even now at the Supreme Court. Let's talk about the Nikki S. Carter versus Department of Ed. What was the basis of that suit, and what was the outcome? Obviously, at a very high level to start.
Sure, I can take that. That's the DC case, and
Yeah.
The plaintiffs in that case were challenging the reduction in force focused on OCR, the Office of Civil Rights, which Derek's mentioned a couple of times, and saying essentially that the reduction would not allow them to carry out the functions they need to carry out. The district court denied that, in part because they did not think that the plaintiffs would be successful on the merits, because they had not shown an actual impact or effect, or that the OCR division had been unable to do its job. It said something to the effect of, it's doing it more slowly, but it's still been able to do it. And so since that's the case, based on the claims you brought, the preliminary injunction was denied in that case.
And to just add some context to that, so we talked about the RIF, right? So my understanding, the Department of Education, at least prior to the recent moves by the Trump administration, had approximately 4,000 or so employees in total. And they were looking to basically slash that by about 50%, more or less across the board. Is that right?
Right. I think the decisions talked about 1,300, almost 1,400 actually employees were reduced total. And then these particular plaintiffs just focused on the OCR part. They were people who had filed OCR complaints, attorneys who had assisted them, and were saying that that would affect that one part of the Department of Education. Then there's the broader case that we'll talk about next that goes beyond OCR.
Yeah. So the other case is the New York versus McMahon decision came out, I think, like 2 weeks ago. Derek, you want to talk a little bit about what was the basis of that case and how that differed from the DC case?
Yeah, I mean, that one has a lot of the same claims that Scott was mentioning, but it sort of goes to whether, the variety of subdepartments in the department can carry out its function. It goes to where the overall department can carry out its function. It goes to whether the administration can move some of those functions out of the Department of Education to some other location. And so, yeah, it was just sort of like, the whole enchilada, I guess, for lack of a better term, of this sort of idea that the administration was carrying out on its promise to make this the final mission of the department, right? To dismantle it and end it. And so so that one is a broader claim there.
And it had a different result than the DC case, right?
Yeah, I mean, on one level, it's hard to line those cases up, beside one another and see why they should get different results. I mean, other than when you move outside of OCR, for instance, right, you have this sort of Reorganization Act, which we mentioned earlier when you were asking questions. And so the statute, designates that these various subdepartments, what they shall be, and that they shall exist in the U.S. Department of Education. And so what you have there is a clearer line about, look, it doesn't matter how many employees you have or you don't have, they need to reside at agency X, and they need to have the name of, subdepartment X, right? And if what the administration is doing is moving them to other locations, that violates the law. Or as I said to my con law students, you actually do not have to be an attorney to understand some of these problems. Had a reporter call me and said, she goes, well, does the Office of Special Education, does the statute require it to be at the Department of Education? And I was like, she was being a good reporter, she was sort of pressing me. And I was kind of, bluffing my way through it for a little while, as we do at times. I said, yeah, let me email you back. I'll call you back. And so I opened up the statute and thought, oh God, I don't want to spend my afternoon, reading, the statute. But I didn't have to, because right there at the very beginning, it said the Office of Special Education Programs shall be in the Department of Education. So you don't have to be an attorney to understand that it is beyond the power of the president to, one, end that office of OSEP, as we call it, or move it over to Health and Human Services, right? You don't have to be an attorney, right? Because ultimately Congress creates agencies, they put them in specific places. And, my point was, it's not up to the president to rewrite the law by putting them somewhere else or closing them down.
So I think this raises a really important point. Well, Scott, were you going to add something? I don't want to cut you off.
Oh, probably to your point. It was just, I think that one of the differences between the two cases was what Derek said, and the case in Massachusetts that granted the preliminary injunction kind of tied the two together and said that the RIF, the reduction in force, is part of the effort to close or dismantle the agency. The administration is arguing that it's not, and there's an appeal before the Supreme Court now to try to stay the injunction, and saying that they're separate, that this is just an effort to reorganize and reduce and be efficient, which is different than our effort to ultimately close the department. And we'll see how all of that plays out. But it adds to those dynamics of what the president can and cannot do that you were asking about.
And so this is the point that I think may confuse a lot of people. People may not really have a good sense of how this works. And I mean, I am a lawyer, obviously, but I'm not a constitutional law expert like you are. So I think one of the things that people have a hard time understanding is the Department of Education is an executive branch agency. The president is obviously the chief executive. He is at the head of the executive branch. Why would Congress be able to put limits on what the executive can do with an executive branch agency? What is that interplay in terms of separation of powers.
Yeah, I mean, and this, it goes to a much bigger question. Hopefully folks will, give me some liberty here. But, you know, in the modern age, there is this expectation, since Congress can't seem to get much done very regularly, that, well, the president will just fix it, right? I mean, people go out and vote and expect the president to fix problems. But the truth of the matter is, outside of war keeping type things, which also has its own separation of powers problems, the president can't just fix things. I mean, he is incredibly powerful. We all know that, but he is his job is to carry out the laws that Congress passes. There's no sort of free-willing power beyond his managerial aspects of the employees that work for him and his functions as commander in chief. And that's not the way it looks when you watch it on TV, but the president can't spend money that Congress doesn't give him. The president can't create agencies that Congress doesn't give him. He cannot prosecute crimes that have not been codified as crimes, right? And so now, is there a lot of discretion once Congress, passes those laws, sort of sub law level? Yeah, of course there is, right? Are you going to prosecute person A or person B? Well, the president can make that decision, but what's a crime remains the same thing. And we could take that, that same point with the agencies, right? It's like, if Congress determines that we need to improve education, we need to protect the environment, like those are congressional decisions. Those are not presidential decisions. If there is no EPA, then the president cannot do anything to affect the environment. If there is no Department of Education, he cannot. Once you create one, there's discretion, but again, it must operate within the scope of those statutes. And, again, the presidency's gotten more powerful over time. And I think, people outside of law schools don't necessarily understand that as well. And then I'll just, finish with this. I mean, I think the trickiest part of these cases, and I think Scott's comments about the DC case sort of had an Easter egg in there, which is Congress, to be clear, cannot hire employees, right? Congress doesn't have the authority to hire Scott to run the Department of Education or me to run it, doesn't have the authority to have us over there, typing in data. Only the president can carry out that function. So it is a shared power that Congress, authorizes money for employees, but it really is only the president who can say, well, that's the employee we ought to hire, or that employee is not doing his or her job, and therefore we ought to fire them, right? Now, the president's not making that particular argument with these cases. He's just saying we don't need these employees, which, I shouldn't go on and on. We can get into that a little bit more, but I think even on that, we don't need these employees. That's an argument that I really was trying to hone in to and push a bit in the Massachusetts case, because the budget that's appropriated each year is a congressional estimation of how many employees we need, right? Or how many we do not need, right? Because the department has been asking for more employees for over a decade, and Congress has said, nope, the number you have right now, that works for us. That's the budget number, right? Although now the president wants less. But in any event, I'd like to hear Scott's perspective on this. He may not be as militant about it as I am.
I appreciate your perspective. And I think I agree with all that. I think that it's an extremely interesting dynamic, as Marty pointed out, and one that law school students in common law should be, applying to what they're learning, with separation of powers and the way that the powers of the executive and the legislative branch kind of play off of each other. The Justice Jackson three-part test, which common law professors talk about, is that, the president's power is at its greatest when it's in accord with what Congress has given it for authority, and at its weakest when it's the opposite of that. And with agencies, it creates this dynamic where Congress creates it, but then the president kind of implements and enforces the laws that both Congress created and then the agency does through regulation. So it's always rife with all these gray areas. And this administration, like prior ones, is made no secret about they want to kind of push the authority of the executive to see what those boundaries are. And there's talk about, the unitary executive theory and all of that, where the president is claiming they do have more authority over agencies. And if they want to, do certain things, they should not need congressional authorization. So that's part of what we're seeing with all of this. And it will be interesting to see how far it can go. The Supreme Court will obviously chime in, at least in part, on the Massachusetts case for the stay, and we'll get maybe some idea of what they think about some of these issues. But the administration does seem to agree that they can't shut down the department without congressional approval. So that's what they've said in their pleadings to the Supreme Court. They seem to acknowledge that part of it. There is an argument that because they have the authority to appoint and remove officials, albeit with some consent, advice and consent of Senate, that they have probably more authority than they've had in the past, with some of the arguments that the Trump administration will probably make around effectuating the agency's operations. And we'll see what the limit is of that.
So, it raises, I think, another interesting question. Derek was talking about the idea that, the president can't enforce a criminal penalty unless Congress has passed a law making it a crime, right? The president wouldn't have authority to act to protect the environment if Congress hadn't established the EPA. This raises sort of the inverse question, though, right? Is if Congress authorizes the money and says there has to be a department, does the president actually have to follow that fully? And how much can the president effectively, gut a department and say, well, I'm not closing it, but since I have authority over hiring and firing, I can fire virtually everybody, right? The majority of people, and effectively make it not function. I mean, at what point does the president's ability to control the management of an entity become so overarching that he effectively is defying Congress? Is there precedent on this, or are we sort of in uncharted territory here?
I mean, there's lots of a number of case sites that are in the opinions, but it's largely uncharted. But there was a couple of things, and again, I'm interested what Scott's reaction to. And most of these are questions we haven't had to seriously think about. And as I began to try to think about them and build out arguments, two things came to me that maybe makes. Well, I don't think all agencies are the same. Let me say that first of all. And so when you look at the Department of Education from a Congress versus president perspective, we get into these murky questions. But when you stop for just a second and go, but wait a minute, like this agency isn't just about Congress and the president. Like the statutes have actually created citizen stakeholders. Right. You've got students who have the right to be free from discrimination in federally funded programs. Right. We have an Office of Civil Rights that is required to investigate those claims. That is required to respond within a specific timeline. We have students, as you mentioned earlier, every year that are hoping to pursue their dreams in higher education and know they don't have the money to afford it, and they need to fill out FAFSA forms, et cetera, et cetera. Like Congress has created a structure that isn't just about sharing powers. I argue they've vested they're not Goldberg versus Kelly entitlements, so to speak, but they have invested these rights. And the idea in students in higher education in K through 12, the idea that the president could effectively deny those students the rights that Congress set up for them, I think that actually changes the conversation. And one piece I added to that was, look, if you think about the Office for Civil Rights, what is it doing? It is saying that your right to be free from discrimination in the nation's schools is not a pay-to-play system, right? We're all lawyers. We know that most of the time you got to pay to play. If you got a complaint, you got to go to court. You got to be able to afford an attorney or hope someone else can cover it for you. But the Office for Civil Rights says, no. These sets of rights are not pay to play. This is a core aspect of education. That's number one. And as I've already said, like we know that we need higher education for this system to function, and students ought to be able to access, loans, and the department's part of it. So that's one piece I think that sort of maybe alters the analysis a little bit here, which is there is a third party that isn't actually talked about that often, at least initially with these. And then the final point I'll make, which comes back to Justice Jackson and Youngstown versus Sheet and Tube that Scott mentioned earlier. There is a disabling function that the executive is engaging in right now, because think about it, right? The power of the purse belongs to Congress. And how is it that Congress knows how much it needs to spend on education on an annual basis? How is it knows what it thinks students might need or what gaps need to be closed? It's all that information gathering that the department does. And so I've suggested that there's another piece here, which is if you allowed the executive in this complex society to shut down our access to information about student outcomes, student need, higher education cost, all of this, that Congress actually wouldn't know what it needed to spend, right? So that we really have this sort of difficulty, which is Congress needs the Department of Education for it to be able to carry out its spending functions responsibly. I mean, that's of course assuming that Congress could be responsible.
Yeah, that's a very good point at the end. And Marty, your question is exactly what's going on, I think. And it'll be really interesting to see what the courts do to address it. There aren't specific cases that deal with that specific issue. There's cases that are around it in terms of authority for Congress, authority for the executive, and it's being tested in this context. If it's split, like the administration wants, just for the RIF, and let's say that that's not related to trying to close the department, but it's just a RIF to try to make it run more efficiently, is what the administration will say. Be interesting to see if any court would say that that's gone too far and that they're not actually, carrying out the laws. The Constitution requires the president to faithfully execute the laws, carry them out. Here, the argument is that by diminishing the department so much, they're not able to do that. And some of that would be a fact question. Going back to the DC case, the DC court found that they did not have evidence that things were actually not being done, just that they weren't being done as well or as timely. And in the Massachusetts case, because they tied things together, they didn't quite address it in the exact same way, but they did make findings about the impact on the states and the students and the schools. And that was enough for that court to grant the preliminary injunction. And it did mention some of the constitutional obligations, but a big part of it was how the court connected what the president, what was happening to the president's directive to ultimately close the agency, and felt that all these actions were connected to that. And that kind of puts it in a different light. So in part, it depends on how it's viewed by the courts.
Yeah, I think there's two. I think Scott there's two. I don't want anyone to think that I'm confident about this, right? Because there are, and I think Scott's hinting. I mean, there's sort of two big sticking points that jump out of my mind. Number one, like during desegregation, right, there were lawsuits filed against HEW for its failure to sort of make schools desegregate, right? There are people that thought that the administration was, sitting on its hands. And those lawsuits failed, right? Because it is clear that there's discretion as to what they're going to prosecute and not prosecute. And so that one has always given me pause. I think that's Weinberger or something like that from the 70s. And so that's a tough one. And the other one, which is what when we find these Supreme Court cases that our students are very upset about, I go, look, sometimes we get results in Supreme Court cases that we don't like because what we have is this sort of spectrum of unconstitutionality. And unless a court can clearly identify the line that can't be crossed, then they just defer over, right, to either Congress wins or the executive wins, and often it's the executive. And I think that's the challenge in this case, which is sort of the Goldilocks problem, is like how at what point is this porridge so hot that you can't eat it, or so many people have been fired that you've disabled Congress or denied rights, and that's not an easy thing to give an answer to. I think there is one maybe, I don't know, tactical mistake, but Congress has been funding 12, I think it was 12, or is it 12 or 8 regional office for civil rights offices for decades, right? Under the understanding that's what was needed to enforce civil rights, protections. And, they closed 4 or 6 of them. I'm having trouble keeping up with my numbers. And so the actual
7, I think it was 7 out of 12, wasn't it?
7 out of 12, right? So the actual closing, and I was in Cleveland a few weeks ago, and they closed down the Cleveland Civil Rights office. I think, that helps a bit with that sort of Goldilocks problem. It's like, well, maybe we don't have to say how much is too much. When you physically close civil rights offices, regional offices, that to me seems, you could call that efficiency, but given that Congress has been funding it for, decades, that seems like a formal retreat that the executive ought not be able to unilaterally do.
And, speaking of the Supreme Court and deferring to the executive, what about handicapping it? Do we expect the court to uphold what the Trump administration is trying to do? I know there's obviously a conservative supermajority right now. Is it as simple as, count the political heads and that's the result, or do you think it's going to be more nuanced than that?
Always hard to predict. On this one case out of Massachusetts with the stay on the injunction, which is what the court has right now. So the Massachusetts court granted an injunction that prohibited the enforcement of the executive order and required the administration to undo the RIF and rehire all of these employees. And the administration asked the court to stay that while they appealed it. The stay was denied. That got appealed to the First Circuit. They denied it. And that's what's before the Supreme Court. It would not surprise me if the Supreme Court reversed the lower courts on that and stayed the injunction to allow the process to go through. That gets into a lot of the dynamics of why you would have a stay and why you would have an injunction that aren't necessarily related to the merits. And there's a lot of details of that we probably don't need to go into. This judge who granted it in Massachusetts actually did that before when the department had canceled some grants and did an injunction, and a stay was not granted, and that got appealed to the Supreme Court, and the Supreme Court overturned the lower court on the stays, just the stay. So I could see them doing something similar like that here to allow it to go forward before they granted it. But I don't know what would happen on the merits exactly, because it will depend on how that Massachusetts case gets refined as we get into the merits of it and what the court ultimately finds. And it keeps connecting the two things, the RIF and the closure of the department, and what evidence they have about that will be really important, I think.
Yeah, I tend to think that the Scott's right. I mean, there are so many, sort of seeing the sausage, I guess, or whatever, seeing this case coming, right? Like there's so many facts that we don't, it's happened so fast, right? So many facts we don't have. And it almost, even if you kind of think it's wrong, I think all students, if they're listening, right, we should always be careful about our gut reactions, right? That facts ought to matter, right? And so we don't really have a full grasp of the facts here. The discovery probably helps a bit, helps a lot here. The other side of it, though, is there are clear boundaries that you don't really need to know the facts, but those go to these sort of larger constitutional questions. So it'd be my guess that the court is not going to want to tackle these super separation of powers issues that we're talking about here. The gravity of anything that it would say about those would be enormous. And without a full vetting of the facts, it just doesn't seem like you should be making big statements about this. I mean, if you go back to our blockbuster, the Pentagon Papers and various other cases, right? I mean, in a very much less divided time, you still had justices saying, hey, we shouldn't be deciding these cases without more information. We're moving too quickly here. So I suspect we will not get, a blockbuster decision, so to speak, out of these anytime in the near future. And I'll just sort of finish that with saying, the last, what I thought there's been a number during the Trump administration, but back when Kerry versus Zivotofsky was a blockbuster case dealing with passports and whether you're going to put Jerusalem, Israel on them. I said, why in the world did the court take this case, right? Why did it jump into this sort of big, huge issues of separation of powers, and then also, Israel on top of that, in a case that was in many respects of not much significance at all? I love that case, but I don't know whether that was smart or not smart. But I think this court will probably stay away from the big issues unless it's just deferred to the president. I mean, I guess they could do that. That wouldn't surprise me as much.
And one of the things that's interesting to me about the McMahon opinion is, Scott's referred to a couple of times, right? When Scott talked about connecting the RIF to the attempt to close it, right? Essentially, the court was imputing motive, right, based on public statements that representatives of the administration, including President Trump himself, had made. And so it's interesting, right? Because do you look at sort of the conduct in a vacuum, or do you look at the conduct in light of circumstantial evidence, statements of the motivation behind the conduct, right? I mean, if the president, in theory, could lay off half of the workforce if he, and again, I know that's the debate whether he could do that, right? But it's interesting to think that the exact same laying off might be unconstitutional or not, depending on whether you consider the motivations for doing it, right? And again, I don't know if there's precedent. I mean, I think I recall with the first Trump travel ban, that was an issue as well, wasn't it? That they were looking
Yeah, that's
maybe
exactly what I was thinking as you
that
were
Trump was
speaking,
making.
is that,
Yeah.
yeah, that you couldn't bring in the motivations. I will say, though, and this, again, we're getting back into the big issues, but the president unquestionably has been recognized as having vastly more powers in the international sphere than in the domestic sphere. And so I do think, I mean, that idea could certainly come into this case, but we are in a completely domestic question here. And at least historically, right, the court has been more protective of Congress in the domestic sphere, sort of the idea that the inherent presidential powers are narrower here. But you're right, on this question of motives, this court, at least in Trump versus Hawaii, said that that's not a road we're going to go down.
So trying to steer us back a little bit more to the practical. So let's talk about, let's say the administration is permitted to do what it's trying to do. Let's talk about where some of these functions will live, if at all. So first of all, the Office of Civil Rights, we've talked about, they're trying to close the majority of the regional offices. Is the Trump administration's plan to basically eliminate the function of OCR, or are they trying to move it to another department? Do we know what their intentions are in that regard?
Well, yeah, I've been talking. I'll let Scott jump in here and I can follow up. Go ahead.
I was just gonna say what I see publicly, right? I mean, it's not information about that, but there's been discussion about moving whatever is left of it to the Department of Justice. But whatever left of it is the key. I don't know, what would be there, and it's unclear how much of the funding. Derek raised some good points about how Congress gets information from the department about how much funding and staff they need. I'm not clear what, if anything, would transfer, but the president has said publicly that that would transfer to the Department of Justice. Special ed would transfer to Health and Human Services. Student loans would transfer to Small Business Administration. I think those are the things that we know in terms of intent. In terms of what happens and how it works is a big mystery.
So I have a question. So OCR moving to justice, I can understand the logic of that, right? Special ed moving to health and human services, right? I can understand that. Why would student loans go to small business administration? What's the connection there?
I'm not sure. I don't know if Derek knows of the background connection between it. It's just what has been said publicly.
Huh.
Yeah, I mean, coming back to that, I mean, there's none of those movements can happen without Congress. That I am clear in my mind about that. And so I think the question is, what can the administration do short of those movements without Congress? And yeah, I think that's the part that's yeah, where we've got this. What's the line between too much and not enough? The OCR, I guess it's just hard for me, which is irrelevant to sort of fathom in my mind, because of the historic role that office has played in opening democracy to communities that have otherwise been excluded, again, whether it be based on race, color, disability, language status. That is, I mean, this isn't just the department. This is, in my mind, sort of core American values. And on this Goldilocks question, as I keep calling it, there is this other piece which I haven't gotten into. So when you sort of look at who actually has lost their jobs, the attorneys, right? The attorneys at the Department of Education, Office of Civil Rights have been the hardest hit, and also with student loans. But you sort of look at not, how can you enforce civil rights law if you let go more than half of the attorneys, right? That's question number one. It's like, well, maybe we could do that. But what we also know from new investigations is that the current administration has been using those attorneys that are left over to investigate new claims of discrimination regarding anti-Semitism, DEI, et cetera, et cetera. And we don't have to get into the merits of whether, Columbia University is rife with anti-Semitism or not, or whether DEI is a problem or not. We can just say that, we cut the staff in half, and more than half, and those who have remained have been assigned to new duties, right? So when you sort of think about that, what we're really talking about, in my mind, is 10 to 25% of the attorneys, if that, who are there to answer the phone if my child has a disability and says their rights have been violated, right? And so, and this is where discovery is important, where we started earlier. Like, do they actually have the capacity, not just to be slow, but to at all answer to claims of discrimination beyond this new agenda, which isn't sort of a response to complaints. It's just an affirmative agenda of the new administration. So I do think there are serious questions as to whether there is anyone at the Department of Education that is going to process, sort of garden variety discrimination claims right now.
So I want to ask a question. This is actually a question from one of the audience members, but I was thinking something along similar lines. So would it be more efficient for Congress just to allocate funds to the states directly and say, hey, you guys have your own offices of OCR, and as long as you enforce these laws and, follow these processes, whatever, we'll keep funding your positions. Would that be a way around this sort of logjam between the executive and Congress?
Well, I mean, theoretically, states could do it, but I want to be clear, but not hostile on this. If we look at sort of the history of education and why we have had an 1867 a Department of Education and then OCR at HEW during the 60s, it is because states have been, uniquely and consistently resistant to equal opportunity over history. I don't think they're at the same place now that they were in the 60s, but the idea that you would let the inmates, so to speak, run the prison is an interesting concept. I think these are largely often reformed inmates, to use that term. And so I'm not entirely uncomfortable with it, but there still has to be some federal oversight. There still needs to be some federal OCR folks that goes, well, we still need to be making sure you guys are doing as good a job as we would be doing, and that you're not being dismissive of, Title VI or Title IX or whatever it may be. So I don't see a world in which Congress could give away all of the responsibility for civil rights enforcement to the states.
The idea that you mentioned, Marty, is something that's being proposed and has been proposed over the years. It's often referred to as a block grant, right? We'll just give the states the money. The states can figure it out. They'll know what to do. One of the issues with that is what Derek mentioned, and just taking special ed as an example, the federal United States Department of Education every year monitors states' efforts to do what they're supposed to do under the IDEA and to implement it appropriately and to make sure it's enforced appropriately. They put out a report card every year. Every year, more than half of the states do not meet all of the requirements under the IDEA. And so if you're just going to let the states determine whether they meet it or not, then you're more than likely going to have, non-compliance with these federal laws, or at least different interpretations of compliance. And that at some level has got to affect students in some way.
I mean, on that point, I sorry for being like Texas. I mean, there was wonderful slash bad, investigative reporting of how much manipulation Texas was engaging in to reduce the number of students who would be identified with disabilities a few years ago. And it was mind-boggling, like, how much they were manipulating data and trying to prevent students from being identified so they didn't have to serve them, right? And so again, I'm not talking about the 60s, I'm talking about 2019, 2021, right? That you have statewide systematic problems on the disability end of things in particular.
One question about student loans, right? Because again, I mean, I think just in terms of the number of students it affects, I don't know if that's more students are affected by that than all of the civil rights issues combined. I don't know the stats, but obviously it's, millions, if not tens of millions of students are relying on student loans. Do we know, is that part of the motivation for trying to take down the department? Is it a hostility to the student loan program generally, or is it more sort of these ideological, whether, I know Derek, you mentioned you think it's based on factual fallacies, but what is this motivation to try and gut or shut down the Department of Education? Is it ideological, or do you think it really is being driven more by efficiency concerns?
Well, publicly, it seems to be a little bit of both. I would say that on the student loan part, most of the discussions have been around efficiency. And where you get into the ideological aspects, it's more around Title IX and gender, DEI, race, those kinds of issues, where the department will make some kind of determination, and then your funding is tied to that determination around issues like bathrooms in public schools or having DEI programs at post-secondary education. Those seem to be more of the headlines that get the ideological aspect to it that's behind some of the efforts today, rather than the student loan part of it. That seemed to be more financial, the student loan piece of it.
Derek, you wanna?
Yeah, I mean, at the broad arc of history, and I started with this earlier. I mean, look, when you say return education to the states, you're talking about returning civil rights to the states, right? And the controversies between the state and federal government around education, they've never been centered around student loans. They've never really been centered around money either. They've been centered around these issues of discrimination and race in particular over time. And so, it just strikes me that, this isn't the same as 1960 or 1954 or the 1876, the end of Reconstruction, but it is an echo of it, this sort of idea that, the feds are coming in here and trying to make us accord to a set of values that we don't accept. Those values being anti-discrimination values. And that's what it looks like, part of it. Now, I'll say the other part of it is just silly political theatrics. I mean, that, it's like, I don't think that, at least based upon public polling, I mean, it says that like 65% of Americans don't think this is a good idea to sort of do away with the department. I mean, it's not as though the department was sort of public enemy number one. What we have with what I call democratic erosion is the need to vilify certain institutions, right, to accrue political power. So on that level, I don't, part of this is about the states' rights stuff, but some of this I think is just sort of trying to manufacture a villain for theatrics and political power. I mean, that's my perspective on it.
So speaking of vilifying institutions, another audience question is, what about, I know it's not exactly about the gutting the Department of Ed per se, but about a month ago, Trump put out an executive order talking about criticizing higher education accreditors, and he actually called out the American Bar Association and the American Medical Association by name. Do we think that something's actually going to come of that, or do you think that's just more, posturing? I'm curious if you guys have any thoughts on that piece of it.
God, I'll let you take the.
Or unless nobody wants to touch that with a 10-foot pole.
Yeah, my only thought is that it will be hard to know until we see something concrete, like an executive order or something along those lines. But it goes back to what I was saying before about the ideological things with gender, race, DEI, things along those lines. That seems to be what's motivating some of that, and organizations making decisions and requiring certain things that a certain group politically doesn't agree with. And the president has been upfront about making statements about trying to change those things, and we'll see to what extent that could be done. You mentioned the ABA for law schools and some of their requirements. There's a variety of things that have led to that happening. I'm not sure the president could undo all of that, through executive actions. So we'll see.
I mean, I think there is something quite large at play here, though, which is, look at, our Ivy League, schools. The department, the administration has identified. Well, let me back up. With an OCR investigation, there's a 5-step process, right? There's a complaint, there's an investigation, there's a presentation of the facts to the alleged violating institution, there's an opportunity to have a remedy. If that remedy is not sufficient, there's a back and forth. And then, some point down the line, maybe there's sort of enforcement efforts. I was in a room with 100 superintendents, and I said, have any of you ever had an OCR complaint closed in, 2 months? Not one hand came up. I said, really? What was it? 6 weeks. I accused him of having paid off the administration. From there, I went up, and there of 100 superintendents in the room, only one there was only one who said they'd ever had a complaint closed in less than 6 months. Right? There's a process here. There's an investigation, et cetera, et cetera. The point of this is what we have seen is the administration claim that there are Title VI violations and impose sanctions in 3, 4, 5 days. It's gone from 0 to 60 in a second, right? Or from day 1 to 6 months in 3 days. And they haven't asked for just remedies to the alleged violation. They've asked for complete restructuring of educational units, receivership. I mean, I go on and on. And so what we really have are sort of claims of violations that haven't been substantiated, and then demands of sort of complete control effectively over institutions, right? 4 or 5 weeks ago, the administration sent out a letter to every state superintendent and every school district in the country, asking them what I call a loyalty pledge to not do illegal DEI, whatever that means. And as I pointed out, no person in the history of the United States of America has ever exerted unilateral authority over our public schools. No person, right? And so when we come back to these accreditors, or we talk about these investigations at Columbia or Harvard, or we talk about any of these issues, I say they all come together with something much bigger than education, which is, right, free speech, right? Sort of contest of ideas. And in a famous case, U.S. versus Barnett, the Supreme Court said that no public, if there is any fixed star in our constitutional constellation, it's that no public official, high or petty, shall dictate what is orthodox in matters of politics, religion, and opinion. And what I see this administration doing is trying to exert unilateral authority to dictate what shall be orthodox, right, in our education institutions and the way we go about it. And I am not here to defend any particular DEI policy. I think we've made mistakes, right? We can do things better. But the point is that for any single individual at the executive level to exert unilateral authority to reshape his institutions is a complete upending of our constitutional principles in the First Amendment and our separation of powers.
Well, since we've got a few minutes left, I was going to ask if you guys had closing thoughts. Derek, it sounded like that might have been your
that's mine. Yeah, Scott, the rest of the
thoughts.
time is yours.
All right, Scott, anything you want to add about anything we've talked about, your personal perspective, your predictions for the future, any sort of thoughts you think are important that we didn't cover that you want to clarify?
Thank you. Very hard to kind of summarize on one thing. Don't want to predict, but I would say, going back to the Kanban and professor part of me, that it will be interesting to see what ends up happening at the Supreme Court level, if anything, around the executive's authority to take these actions. They have for the past 5-10 years in the administrative context been giving the executive, the president, authority around removal of agents, agency heads, for example, is just one little example, and to try to give more authority to the president, it seems, and streamlining some of that. So it wouldn't surprise me if some of that happened. Don't know to what extent on some of these issues. The administration, I'm sure, will push that around the unitary executive theory. They should have as much control as possible over the agency, will be their claim. And we'll see exactly how far that stretches in the context of this or some of the other agency issues that are coming up.
Well, thank you for that. I want to thank both of you once again for taking the time to talk about this subject. I think it's fascinating. It's obviously very important and timely. And if I can just add my 2 cents to the audience, as someone who has taught law for over 2 decades, I of course find this interesting from a legal perspective, but just as a citizen, I find it interesting. And I do find that when I just read general news articles, and not accusing journalists of having any bias necessarily, but well-meaning lay people don't always understand or are not able to clearly articulate what the actual underlying legal issues are. Sometimes, frankly, they choose not to get into the guts because they're worried that their general readers will fall asleep. But I encourage people to do your homework and look into these issues. I think whatever your politics, it's important that we have an informed citizenry, a curious citizenry, It's important that we are aware of what our government is doing, of what's at issue, of what's up for debate, and that we actively participate in that in a civil and informed way. So that's just my general pitch for all of this. So thank you again, and thank you all for taking time out of the middle of your day to hear an hour about the Department of Education. I know it's not Netflix, but I think it's interesting and certainly important. And I want to thank you all again. Thanks to all those behind the scenes who made this webinar possible. You're not seeing them, but they're essential as well. And I look forward to seeing you at the next one of these. So take care, everybody.
Thank you.
Thank you.